All right, so now we know what happens when you want to drill a well. We know that you have to follow the spacing requirements to figure out where you drill that well, and that once you have the well, you are stuck following the allowables requirement. So you can only produce a certain amount per day. But what happens when you have a really small piece of property where you are never going to get a well under the normal field rules? So we spent a lot of time looking at 80-acre properties, 40-acre properties, 160-acre properties. What if you just have a 5-acre property or a 10-acre property? How are you supposed to drill a well unless the well happens to be on your property? And if you can't drill a well, how are you going to get that oil and gas? Well, that's what we call the small tract problem. And the general solution to it is one that we've said something about already, which is pooling. And we'll talk a little bit more about what exactly pooling is today. But there are other ways that you could try to address it. And we see that Texas actually took a very circuitous route to getting to something that is mostly pooling, but it tried a lot of other options before that. Sometimes if you look at the history of how Texas addressed these small tract problems, it sort of brings to mind a quote that's often attributed to Winston Churchill, probably wasn't Winston Churchill, but he said, you know, Americans can always be counted to do the right thing after they've exhausted all the other options. And that's kind of what Texas did on pooling. It tried everything else, and finally it went with pooling, which is what the other states had settled on much earlier. So let's talk about what is pooling. Well, pooling is basically when you're getting enough land together for a single well. So let's imagine that you have 8 owners that each own 10 acres, and you're supposed to have a drilling unit of 80 acres. Those 8 owners can get together and pool their land to drill a single well. They can share costs of that well, and they can share in the revenues from that well. So pooling is when you get land together, usually almost always for a single well. So bringing small tracts together for a single well. Unitization is sometimes confused with it, but is very different. Unitization is more complex. It says, instead of just getting one drilling unit together, why don't we just cover the whole reservoir? The reservoir could be 8,000 acres or 80,000 acres. It could be huge. And what we want to do is coordinate our production on this entire reservoir. So maybe it doesn't make sense to have a well every 80 acres. Maybe we only need a few wells on the north side. Or maybe we need a few wells on the north side and some wells on the south side that are not producing, but are pushing in water and gas to push that oil up north to our producing wells. So there's a lot of different ways to produce things from that entire reservoir. So unitization is the process that unitizes, coordinates production along a whole reservoir to get the maximum production from that whole reservoir. So it tends to be more efficient than pooling, which is just a way of making sure we have one every 80 acres or 40 acres, which may not be exactly precisely what's required, but is better than having just well after well lined up next to each other. So unitization is more efficient if you can do it. The problem is, you try to think about, let's say you have 10,000 acres for a reservoir. How are you going to get all of those owners to all coordinate on doing one plan of production for all of it and agreeing how they're going to share it all? So unitization is very common in the international context, where you're talking about just a couple big oil companies that can negotiate with each other, but it is much rarer in the United States onshore, where it could be really hard to get all those owners together. So today we're talking about pooling, which isn't that whole reservoir-wide, coordination. It's just, hey, if a drilling unit is 80 acres, how do we get a bunch of small tracts together so we've got 80 acres to pool to drill a single well? Okay, so why would you want to pool? Well, the first reason is if you sit on the same reservoir as your neighbor, how do you protect your interest? If you're on a big property, go ahead and drill your own well. However, if you're on a really small property, maybe you can't drill a well because your well would be too close to another one, or there's already a well within your 40-acre or 80-acre unit, so you're not going to get an exception. So the alternative is that you could pool with the other owners in the same drilling unit and share a well together. So what happens when you're in the same drilling unit? Last video, we looked at this example and we said, okay, imagine that in this particular field, you get to drill a well every 20 acres. Black acre is 20 acres, white acre is 20 acres. That's great, they both get a well. There might be problems with white acre needing an exception well, but the basic reality that both sides get one well makes a lot of sense. But what if, instead of needing 20 acres to drill, in this field, you need 40 acres to drill? So you need 40 acres to drill, black acre is just 20 acres, and white acre is just 20 acres. Well, it would still make a lot of sense for black acre to drill because, as you see, black acre's radial drainage drains that entire reservoir, it goes right up to that reservoir edge. So we really only need one well. But it seems really unfair that white acre doesn't get anything in that scenario. So pooling is made to address that. Basically, black acre and white acre come together and they share the cost and the revenue from that single well that's going to produce all the oil on both of their properties. So that's what pooling is. Now, what I have to tell you is that Texas initially took a different approach. So Texas took the approach of just allowing exception locations. So instead of saying, hey, white acre, you share in what black acre did, they said, you know what, even though you don't have enough land, go ahead and drill yourself, white acre. Now, maybe that works where each is 20 acres, it's not ludicrous. But what if you had a suburban development where each party has less than an acre? What if everybody's got, townhomes? That is just not feasible. And we'll see some of the absurdities that it created. But that was the initial approach that Texas said, is that, look, everybody gets the right to drill a well, even if they don't have the biggest property. But we'll see some of the problems that created. So the rule was, generally, you could get an exception well, even if you didn't have enough property, if not giving you an exception well would result in waste or failure to protect correlative rights. Now, if you have a really small property, will not having a well result in waste? Probably not, because probably there will not be any oil and gas left in the ground. Your neighbors are just going to pump all your oil and gas. So it's not really waste. The bigger issue is failure to protect correlative rights. In other words, you had oil and gas underneath your property and somebody pumped it away unless you get that exception well. So in Texas, those exception locations, exceptions to prevent confiscation, have been used to deal with the small tract problem. So rather than allowing white acre to pool, you just say, okay, white acre, you get your own well. So that's a Rule 37 exception described on page 765 in your book. Now, Rule 37 is the spacing rule. So that says you have to be 467 feet from the property line and 1,200 feet from another well. There's also a density rule. Often, it really varies, but often you need to have 40 acres for oil, so you can't have more than one well every 40 acres, and you can't have more than one gas well every 160 acres. Again, gas acreages tend to be bigger because gas flows more easily. Also, gas is not as valuable, and so it just doesn't make sense to spend all the money on lots of gas wells really close to each other. You'd rather have just a few wells, each of them producing a lot of gas to justify the cost of drilling. So that exception to prevent confiscation, that Rule 37 exception, says, you know what, if you don't have that, because you have a smaller property, no problem. go ahead and drill your own well. So that Rule 37 exception has generally been given as a matter of right. So it's not just that the Railroad Commission usually gives it to you. It's that you just have a right to drill a well on your own land. Now that right eventually had to be limited, and we'll see why, and I'll summarize this at the end, but it had to be limited by the voluntary subdivision rule. Because remember what happened because of the rule of capture before there were density or spacing limitations. Well, what happened is that we had people putting wells right next to each other. Like, why would you do that if it's on your property? Well, more wells means you can pump harder, means you can produce more. And what we'll see is Texas, for a while, had the rule set up so that more wells gave you more allowables and allowed you to pump more. So nowadays, you can't have multiple wells on one property. But what if your neighbor has 40 acres, so they get one well, and you have 40 acres and you'd like a lot of wells? Or you think the land would be more valuable if it had a lot of wells on it? Well, what if you sell all of your 40 acres to people in 1 acre lots, and each of those 1 acre owners thinks, this is great because I get an exception as a matter of right to have my own oil well. So yeah, it's not worth as much as a 40 acre property, but I get an oil well on it. And as a result, those 40 acres in tandem are worth more than the neighbor's 40 acre property because you get to have 40 wells on that, on what used to be one property. Okay, so that is what's called a voluntary subdivision. If you already know there's oil there and you subdivide your property, the Texas Railroad Commission does not give you that exception. Okay? The voluntary subdivision rule, we'll talk about it. That voluntary subdivision rule is limited by the Century Doctrine and Rhines versus Pickens, which we'll talk about. I'll talk about what each of those things are. Basically, the Century Doctrine says that if you're a subdivided property, so there's 41 acre units, one of those 40 units will get to have a well. Here's where things got a little bit crazy. Texas also said small tracts get smaller but living allowable. So remember earlier I said the amount of allowable you get is based on your acreage in most places at most times. But Texas thought that was a little bit unfair to the small landowners because the small landowners said, okay, so you say I get this well as a matter of right, but I've only got half an acre here. So my allowables are just tiny. That doesn't justify having a well. And so Texas said, you know what, you should have living allowables. Because the idea is, you're in Texas, if you don't have an oil well, are you really living? Maybe not. So they said you should have living allowables, i.e. enough oil allowed to produce that you could pay for a well. We'll talk about it. Those living allowables. They come as Railroad Commission versus Humboldt-Hawkins Field case. So that small tract gets a living allowable, and it provides an opportunity to recover the cost of drilling. But they get overturned in this Port Acres case, it's sometimes called, Al Booty versus Railroad Commission from 1962. And that just says, enough with the craziness, because the problem was all these tiny little, especially if you had a development, suburban properties, et cetera, you'd get tiny little wells all getting living allowables, so producing mostly from the field, and it's almost as bad as the original days rule of capture that you all saw, those pictures of Huntington Beach, or Venice Beach, just well after well, right next to each other. So the 1962 case says, no, we're gonna go with a fair share rule, so it's not gonna be, which basically tends to be acreage, so no more living allowables. But this continues to be relevant because there were a number of wells that were drilled under this living allowables regime. And the new rule from 1962 only applied to new fields. As you read in my article, there are leases with oil wells that have been operating for over 100 years. So if you have a really old oil well, possible that they're still under this living allowable system. So there's definitely wells still using these old systems that Texas developed. And I should note also, it applies prospectively to new fields. So if there was a field, even if the well is relatively new, it comes after 62, if that well is drilled in a field that was discovered before 1962, and remember, the first big Texas oil boom lasts from basically 1930 to 1950, 55. So there are a number of wells that come in during this period, or fields where if people drill a well, it's still covered by these living allowables. Okay, so obviously these rules create a huge incentive to have small properties because, of course, more acreage is always worth more than less acreage. But if you have one property, two 40-acre properties next to each other, okay? One will just get one well. If you subdivide this into 4 10-acre properties, each will get a well. And so you could actually make more money by selling it out subdivided, because you're basically selling the right to drill all these different wells, each of which are going to get living allowables. So that's why the voluntary subdivision rule, which is part of Rule 37, was necessary. I'll just read that to you. Any subdivision of property creating a tract of such size and shape that it is necessary to obtain an exception to the spacing rule before a well can be drilled thereon is a voluntary subdivision and not entitled to a permit to prevent confiscation of property if it were either segregated from a larger tract in contemplation of oil, gas, or geothermal resource development, or segregated by fee title conveyance from larger tract after the spacing rule became effective for the voluntary subdivision rule attached. The date of attachment of the voluntary subdivision rule is the date of discovery, regardless of subsequent lateral extensions of such reservoir. So the date is the date of discovery of the reservoir. So if you subdivide your property after a reservoir is found close to you, you can't say, oh, well, I didn't know there was oil and gas under my property. I thought maybe it just was over there. If you're on that same reservoir, then the voluntary subdivision rule prevents you from being able to drill on all those subdivided properties. There's lots of different reservoirs vertically. One thing we'll talk about with fracking is that there's often one reservoir on top of another on top of another. The date of attachment is the earliest that one is found. So basically, if you know there's oil and gas in the area, the voluntary subdivision rule will apply. There's merged fields, then it's the earliest discovery date for the whole new. Finally, there is an equitable escape hatch in this rule, which says, if any reason it's extremely unfair, you may be allowed to have an exception well. But that's pretty rare. Typically, if it's voluntarily subdivided, you're not going to get that exception as of right. All right. Further complication to that. So remember, now let's imagine we have these 4 properties. They've been subdivided. You need 40 acres to drill, and they've been subdivided. So nobody has enough acreage to drill. And the voluntary subdivision rule applies, so you can't get the exception as of right. So does that mean nobody can drill? Well, the Century Doctrine says, okay, if nobody's drilled, then you get at least one. So where independently of voluntary segregation, the larger tract, including the segregated tract, is entitled to an additional well. So basically all 40 acres, if you take all 4 properties combined, would be entitled to a well. Then, to protect the vested rights of the owners of such larger tract to recover their fair share, the permit to drill on the segregated tract will be upheld, even though the application be made to drill only upon the voluntarily segregated tract and only by the owners of that tract, and be contested by the owners of the remaining portion of the larger tract. So if you're the first to drill, you can go ahead and drill one, but your neighbors are not going to be able to drill. And that's actually confirmed by this case that's referenced on page 769 of your book, which is the Ryan Consolidated Petroleum Corp versus Pickens. And in that case, Pickens and Ryan both own part of the tract that was subdivided after oil discovery. So because of the voluntary subdivision rule, unless somebody gets an exception, nobody's going to get a permit. The Railroad Commission gave Pickens a permit to drill where it's best to develop the whole tract. So kind of like Blackacre in that Blackacre and Whiteacre scenario. Ryan sues, says, hey, you're taking my oil. Well, it's a little surprising, but the court and the Railroad Commission say, okay, Pickens, you get to keep all that oil. So we need to have protection of the whole tract. And so whoever asks for that exception well first gets it under the century doctrine. So what does that suggest? What do you have to do in this case? Well, obviously it suggests you should go to the Railroad Commission if you're on a subdivided property and ask to drill as soon as you can, because the first person to get it is going to be the only person to get it, because everybody else will be denied by the voluntary subdivision. In practice, usually that means you're going to want a pool. And the reason is, if everybody goes to the Railroad Commission at the same time, Railroad Commission, it's not going to like say, oh, you were filed 5 minutes before you, therefore we're going to give it. You don't know what they're going to do. And so usually the owners come together and say, you know what, let's go ahead and split this. Let's go ahead and split this well. So Ryan, got kind of unlucky here, but in the future, usually what happens is the small tract owners come together and pool for that well. Okay, so to summarize, brief history of how Texas conservation law got where it was today. So obviously you have the rule of capture, but there are these spacing and distance rules. Rule 37 for distance from the property line and distance from other wells. Rule 38 for spacing. And you have allowables, but there are exceptions for exception locations. So you get an exception location if you have a smaller property, and for living allowables. So at least historically on old fields discovered between 46 and 62, you have the ability to get living allowables, which is basically enough to make the oil and gas well worthwhile. But that has been limited by the Port Acres case, which says that for newer fields after 1962, you don't get living allowables. And that exception as of right has been limited by the voluntary subdivision rule that says if you divided your property after the oil and gas reservoir was discovered, you don't get an exception well, unless you're the very first person to ask for it under the century doctrine. But there's only one well allowed, and that's what the Ryan versus Pickens case does.